I've got a question about trademark record and its first use in commerce. I'm the manufacturer. I produce some goods and have registered mark in my country. I'm guessing not the US. So the question is, if someone will start selling products, not their products with my logo, but my products on the territory in the US, who will have the priority over my trademark? This person who began selling it commercially by selling my products for me, because it's my product and all the info about the label is about more and more. Okay, did you get enough on that?
Yeah. So
Okay.
this seems like this individual, to frame it up right, let's just say they're in the UK, they have a product, they have a trademark in the UK, and someone's buying them and selling them in the United States and kind of claiming to be them, right? Who's got priority of use in the United States? Well, technically, like this third party is the one using the trademark in the United States, but they don't have any trademark rights because they don't actually own the trademark or the brand, right? If they were to, go to the USPTO and say, we're this company and this is our brand, well, they're committing fraud on the USPTO by doing so, because those products are not their products, right? They're a third-party reseller of those products.
Ooh, that's cool. Interesting. Okay.
Yeah,
so you're saying real quick, so the person selling, if they're putting their brand on, they're sort
if they're putting their own brand on this third party's products and selling in the United States, that's fine. Right?
Okay.
But for my money, I would say that taking someone else's products from a third party country and then claiming to be that company here in the United States, that's fraud on the USPTO to move forward with an application. That's how I would pursue litigation against this company. Would be, we'd file our own trademark application in the United States on behalf of like the UK company, right? And then if we had to, we'd pursue litigation against the third party in the United States claiming to be the company that sells those products. That's how I go about it. It's a little complicated, right? Because at the end of the day, you get rights based on use in commerce here in the United States. So if you're selling products in the United States, if you're offering products or services for sale in the United States, technically you have first use of that product or name. But if you're holding yourself out to be a third party or a company that you're not, that's fraudulent behavior, and the USPTO doesn't look kindly on that.
Perfect. Thank you, Matt.